All right, counsel. First of all, are there any other witnesses or any other evidence to be submitted from either side?
No, Your Honor.
No, Your Honor.
Service? Okay. Anything else from respondent?
Your Honor, we would like to make a closing statement.
All right. All right. I will allow a brief closing. Go ahead whenever you're ready.
Thank you, Your Honor. Our client, who is a 16-year-old child, Fatima Touré, comes before this honorable immigration court seeking the protection of the United States. You have heard her credible testimony. It has been consistent, detailed, and specific throughout. Ms. Touré has proven that she's experienced and faces persecution in Guinea. She was repeatedly and viciously harassed, threatened, imprisoned, detained, beaten, and raped, all as a child, by dictatorial President Conte's presidential guard. There are three reasons why this misfortune befell her. Three reasons that are protected by U.S. asylum law. She was persecuted because of her Malinke ethnicity, as well as her actual and imputed political opinion opposed to the dictatorial regime of President Conte, as well as the third reason is because of her family relationship, her kinship relationship to her uncle, who was a very prominent political activist. There's no doubt that Fatima was persecuted. She was arrested 7 times, handcuffed, and taken to jail by armed presidential guards. It is notable that these presidential guards lacked any legal authority to conduct an arrest and to detain her, and this has been substantiated by our expert testimony as well as Ghanaian law that has been submitted to the record. Each time that she had been arrested and detained, she was physically and psychologically abused. She sustained significant injuries during the course of this abuse. She has presented to the court 4 scars to her finger, her head, and her knees. She suffered rape in their custody. The psychological harm lingers to date. She contends with post-traumatic stress disorder and faces further harm in Guinea without adequate mental health care. The Board of Immigration Appeals has instructed judges to evaluate the totality of the circumstances when deciding asylum claims. In this case, all of the torture, and particularly the physical and psychological abuse and the rape, considered collectively, compel the conclusion that Fatima suffered persecution in the strongest sense of the word. There's a compelling case to be made that she deserves asylum based on past persecution alone, irrespective of a threat, individualized threat of future persecution. Matter of DV, Board of Immigration Appeals decision stands for the proposition that a person who has suffered rape constitutes past persecution. Fatima is now alone in the United States and contends with very significant psychological disabilities related to the rape. Fatima also has met her burden of proof for showing a fear of future persecution if returned to Guinea. In this case, both for past persecution and future persecution, the 4 matter of Acosta elements are satisfied. She was harmed, clearly harmed, because of her relationship to her uncle, political opponent, her own political activities, as well as her Malinke ethnicities.
Counsel, let me stop you there just briefly. I'm going to cut this short briefly, but her own political activities, I'm not sure I heard that in the testimony, and her own political activities, where was that?
She was politically active in Guinea and attended meetings, and when the guards, when she was arrested and detained, the guards were targeting her both because she was Malinke and imputing a political opinion.
Well, I can understand that, again, and I'll ask you to move on, but I just did not hear in the testimony much evidence of her own political activities.
In terms of the nexus with family, as the court knows, there are several cases which stand for the proposition that the immediate family can be a cognizable particular social group for asylum eligibility. Geber Michael from the First Circuit establishes that case, and it was followed recently by the Ninth Circuit in Chen. So, because of her family relation to her uncle, who was really acting as a de facto father to her, she experienced past persecution and faces future persecution if she's returned as part of the immediate family. If the court feels that those cases do not apply, because technically, legally, he was not her father, there is also matter of H, Board of Immigration Appeals decision standing for the proposition that kinship structures can constitute a particular social group. So therefore, her extended family and relationship to the uncle could also constitute a particular social group. As you heard from expert witnesses today, the Malinki definitely demonstrate different cultural and physical characteristics which are known to others within Guinea, and that the president's tribe is the Susu tribe, and there's a divide and conquer strategy between the groups. So if you're Malinki, you can have a political opinion imputed against you, and she's readily identifiable as Malinki, both by her last name as well as because of her physical features. There is no way that she could hide being Malinki. Finally, regarding her testimony, we do want the court to take note of what the expert witness, the mental health expert witness, had to say, that survivors of post-traumatic stress disorder might not necessarily testify as cogently or with, respond with emotions that we would necessarily expect during testimony. Their demeanor sometimes can be cold, can be diffident, can be aloof when we're expecting more emotion from the witness. We finally want to conclude with that, with noting that for purposes of asylum eligibility, Fatima has clearly met her burden to just show a 10% risk of persecution if she's returned to Guinea, a 1 in 10 chance that she would be harmed. She also has met her burden based on the egregious past persecution that she experienced, including rape and torture, that she faces a 50% risk, a more than 50% risk of harm if she returns to Guinea under withholding of removal, and should be granted withholding of removal as well as asylum. If the court is not going to grant asylum or withholding of removal, we also contend that she has met her burden of proof that she has experienced and faces torture in Guinea, torture and merits protection under the United Nations Convention Against Torture, Article 3 of the United Nations Convention Against Torture. It is notable that she has evidenced her torture to the court in the forms of the scars, the injuries that she sustained from the beatings that were inflicted, as well as rape has also been held under international case law, which is cited in our brief, to constitute a form of torture. In the alternative, if our relief requested is not granted, we would be forced to seek voluntary departure.
I don't think she's statutorily eligible for voluntary departure at this point, but I will certainly consider your relief application.